Law&Crime Network is in South Carolina, where we're covering Timothy Jones. He killed his 5 children. On the stand are their mother, Amber Kaiser. Let's go into the courtroom and cry along with her. Okay, so when you try a death penalty case, you start actually by preparing mitigation. Gene Rossi, my guest for the afternoon, my Gene Rossi. Gene, how are you?
I'm doing well, but I'm still here in the trial.
Oh, my goodness gracious. So, yeah, Gene said he's still here in the trial in his ear, and we want everyone now to focus on us because we are going to talk about this trial. Gene, this is Deborah Gray. She's a social worker, and she's going through, again, a lot of things the jury has heard. But earlier today, before you sat down, she said something that really just like, oh, I went, wow. She said that he carried a Bible around with him for a period of time, that he believed in the literalness of the Bible. And we should talk about Cain and Abel, talking about literalness of the Bible, and that he thought that children could be demon-possessed, and get this, that he spoke in tongues in the living room sometimes when he was young. Does this sound like another case we recently had here on the Law&Crime Network?
Yeah, it sounds like the state that's right near Georgia on
Florida,
the Atlantic Ocean.
Okay, and it is John Chuck, who carried a big Bible, remember, and also believed that children could be demon-possessed and talk in tongues. So what is going on here? Do you think that this is legitimate testimony, or do you think that somehow John Chuck has infiltrated South Carolina in the Tim Jones case?
What I think is happening is you have a lot of defense attorneys who specialize in capital cases, and they compare notes, they go to conferences, they have meetings, and I'm sure that they shared notes. It's a club, and it's a good club because they do great work protecting somebody's life. So this is very similar. Here's the problem I have with this defense. He was an only child. He was sort of pampered. He had mommy issues. It doesn't seem like he was beaten or assaulted when he was young. He just had a childhood that wasn't perfect.
Well, his mother did have schizophrenia, and she didn't take care of him, and he now has schizophrenia. So I don't think we can say that the mommy issues may have been the ones that you're beating, but certainly you could abuse a child by not changing the diaper, not talking to them, not holding them, not loving them, right?
Yes, and I think I heard that he rarely saw his mother. Is that it?
Right, correct. Because she withdrew. She withdrew. As part of the schizophrenia, here's the face. She just withdrew from the world, right?
But here's an anecdote that I want to talk about. I talked about it yesterday. In Prince William County, Virginia, about 15 or 20 years ago, a 24-year-old kid was charged with capital murder. It was a drug case. He had one of his suppliers killed, or one of his customers who didn't pay, had him killed. And the mother, in the death penalty phase, testified allegedly for the defendant, and her testimony was horrible. She didn't really care, yes or no, whether he got the death penalty, and you got the feeling that she didn't like her son.
Well, here, Gene, here's what happened yesterday and today.
Yeah.
His father, Tim Jones' father, testified, and I thought he was effective. And most effective was his grandmother, who says, "Please, I'm a victim of this. Don't take my grandson. I've lost the children." And then today, the mother of the children, Amber, testified, and she was like, "Well, I'm just going to leave it to the jury what happens." So that's always a problem when you're trying a death penalty case and you're the defense.
That's horrible. And if the mother was called by the defense, I assume, they had to know that she's going to act like that. I don't know if I would have called the mother. Now,
well, let me just say to you, there's something that always bothers me in this case is she wasn't working, and yet he had a good job, so she said she made a decision to let the kids stay with him. But if she wasn't working, then she could have taken care of the kids in the day when he was off working for a job. And I just don't understand this dynamic, and maybe the defense wants to see this non-understandable dynamic.
That it was just a messed up family, that he had a mommy issue. There was coldness, detachment between him and his mother. I get that. But if the mother gets up there and basically says, hey, You're the referee. You decide the jump ball. No way. Oh, my
Well,
goodness.
Gene, I'll tell you what, death penalty cases are terrible. The deaths of these children are terrible. I don't know what this jury is going to do. Okay, so that is the judge in the Kellen Winslow case, who I thought generally was fabulous through the whole trial. But, Gene, I sensed a little bit of pique there on the defense motion for dismissal. Let me just set up to what happened here. The jury came back yesterday, and they said they had a verdict on 4 counts, right? They had a guilty on Jane Doe number 2, right? They had a guilty dealing with the older woman, Jane Doe number 5, at the gym. That was guilty. They had a not guilty on the hot tub incident at the gym. And they also had a guilty on, who I thought was a fabulous witness, was the bicycle incident where he was allegedly masturbating, feeling himself up too. So the only rape they found him guilty on was the homeless woman, Jane Doe number 2, but they found there was no other special rapes to give him a life sentence. They were hung 3 to 9 on that, it turns out. Now the judge is getting piqued there. Why?
Well, because the defense attorney is trying to raise an appellate issue where under a Supreme Court case called Apprendi, if there is a fact that the court has to consider in imposing a life sentence, and it is a fact that can raise the maximum of a sentence.
And this was, just to be clear, this was, if they had found other rapes, this would raise the maximum of the sentence on the victim on number 2, right?
I got to tell you, this defense attorney, both of them are great, because they are focusing on a key issue. He's found guilty, so they're not going to fight that one unless they're going to appeal. But they're worried about the maximum sentence. And there's a fact that if the jury finds this fact, the judge can impose life, and that is multiple victims.
But when the jury came back, when the jury came back and said, we are hung on that, that told you we were also hung on Jane Doe number 1 and Jane Doe number 4. Jane Doe number 1 being the one who had the daughter who came in afterwards and had the GoFundMe page, and Jane Doe number 4 was the one who was allegedly 17 years old when Kellen Winslow was 19, correct?
Absolutely. Yeah, Jane Doe 4 is the one who's married to someone in the military and was 17 when she was allegedly raped. Jane Doe 1, we all know Jane Doe 1. That was the one with the daughter who had a GoFundMe page. So all you have now is, if my arithmetic's right, you got Jane Doe 2 guilty. You have, and that's it.
Yeah, Jane, you know what? Let's listen to the judge question the jury about their verdicts, and then we'll talk again on the other side. So stay tuned. Let's watch. Well, that's an interesting procedure, Gene Rossi, my guest, my always guest, my lovely guest, and I've been there on the Phil Spector case. California is the only place I've been in all the states I've tried cases in that allows a judge to do this in open court. And then they decide based on these numbers, the prosecutor, whether or not they're going to retry the case. Have you ever seen this before?
Well, I have seen where the judge, if there's a hung jury, and I've had a few hung juries, the judge will say, okay, Madam Foreperson or Mr. Foreman, write on a piece of paper what your split is. And we will please give that to the court. It could be helpful. And they write it on a piece of paper. I've had 11 to 1. I've had 10 to 2, 9 to 3, 5 to 7. It's a number that can always determine whether I'm going to go forward.
That's right. And as a matter of fact, usually when you have a 10-2, you may go forward. But if you have a 5-7, which 5 not guilty, 7, you may not go forward, right? Oh, down. Why? But because no. Why?
My rule of thumb was this. If you have 9-3 or 10-2 or 11-1, you're going to retry it. But if you have 7-5 or 8-4, I'm kind of wobbly. I'm wobbly.
You're wobbly. Well, how about it be wobbly? Would you, if you're going to be wobbly and you're going to retry it, would you take the fact that you have, assuming the victim, Jane Doe number 4, wants to go through this again, would you take the fact that you have a 10-2 on the one part and then an 8-4 and then still attach Jane Doe number 1 because you think that it shows pervert sitting in that seat over there, ladies and gentlemen? I can't really prove it to you with 1, but you know the intent here.
If I'm the government I'm going to declare victory and go home. They got a couple of guilties. Move on. I would not put Jane Doe 4, Jane Doe 1, or Jane Doe 5 through another trial. The judge will probably kill the prosecutors. But I got to say this, though, Linda.
Yeah?
The Law&Crime Network over the last 3 weeks, whether it's you and I, Kumbaya, me and Bianchi, Rachel Stockman, we almost called these verdicts.
Absolutely.
I'm telling you, we were very skeptical of 1, of 4.
Well, I wasn't so skeptical of 4. I thought there was problems in the sense that she'd waited a long time, that she had consensual sex, and that given what was happening, I thought they should have brought the other friend in. I can't remember his name. Giving him immunity and let him tell what happens.
Yes.
Right. And then they could have guaranteed a conviction, in my opinion.
You're agreeing with me, though.
Oh, my God.
If they had brought that friend in, the guy, Matt,
right.
I think his
Matt,
name was,
right.
it was a guy. If they have given him immunity and brought him in, they would have had guilty on Jane Doe 4.
Right, and we talked about that. We talked about that because to me, she affected me. I really was upset listening to her testimony. Her cross, though she has some problems in the cross, but I thought that they had to bring him in and guarantee that conviction, and they didn't for some reason want to find him, want to give him immunity. I don't know why. They may know better than me. We're just sitting here armchairing this.
We are armchair, and that's why we get paid the big bucks, okay? But here's the thing. Here's why I feel great about the network and working with you and all the folks in Law&Crime Network. We called this, and what's beautiful is this: the viewers, they were seeing the cross-examination openings, the inconsistencies, and I got to give an A+ to those defense attorneys, all 3 of them. They did a great job. Kellen Winslow was paddling upstream on the freaking Colorado River, and it was a tough. You got 5 women saying that you're basically a pervert and a rapist. That's a tough road to hoe. It really is. It
really is. So without that GoFundMe page up there, Jean Rossi, my prosecutor forever, you know, she testified, the mom testified, and we know that Kellen Winslow was picking up people that he thought were vulnerable. I mean, he could have picked up somebody who he thought was mentally ill, who was vulnerable, who he thought was a streetwalker. People get raped. They get raped in hospitals. They get raped in facilities. Why did the prosecution just do what I just did instead of going here and leaving themselves open?
By calling the daughter, you mean? Why'd they leave them? Yeah, can you hear me?
Can we hear Jean?
Hello?
Oh, there you are. There you are. You were being bleeped.
Oh, no, because I was shoving my face into the camera. No, what was your question? Repeat
I mean,
that.
why did they just let it go and let argue that he picked on vulnerable people?
They couldn't let it go because that was the first witness, essentially. And
it was.
And John Doe. Jane Doe 1, as I said before, she was not a home run. God bless her. Something happened, but her testimony just wasn't good. The prosecutors realized that. The daughter realized that and talked to somebody and said, hey, your mother's count is going down the tubes. You got to do something. And that kind of came out in cross-examination, I can tell you that.
Yeah, but did it also come out that maybe the daughter thought, let me see, where's my wallet? I can now get some money on a GoFundMe page. And you know what? Maybe it won't all go to my mother because I'm going to take care of her and I'm going to get a fee for that. I mean, to me, that's what came out.
It was a twofer. I'm going to help my mother. I'm going to help my mother because the count's going down. And the daughter said, hey, you know what? I'm going to make some money doing this. Everybody's happy.
Yeah, Jean, and you know, we're going to go to break, but also because we knew the daughter's name, everybody could figure out the mother's name. She did her mom a disservice. She did her rape victim. If she wasn't a rape victim, because we don't know, because it's just an allegation, a disservice. That is Amber Kaiser, the mother of the 5 deceased children. Jean Rossi, you know, we pay attention to victims in this country, and she is a victim along with his family. And she's saying, you know, I don't want his family to feel the loss I have. I pray for him. I know everyone's affected, but I pray for him. How do you think the jury takes that after listening and seeing the pictures of the dead children?
I got to tell you, if I were a juror, that's probably the most powerful witness in an entire trial. regardless of whether it's the penalty phase or the guilt phase.
Well,
That was
Gene, shouldn't the state pay attention to when the closest relatives don't want somebody executed like they did in the Christopher Watt case out in California when both sides didn't want the son executed for killing the daughter and the 2 kids? Shouldn't they pay attention, or do they go forward like they're doing here and say, okay, jury, kill him?
I think the prosecutors have made the decision that let the jury decide whether he should have life or death. And the victims, we take into consideration their views. But even though the mother and this is the spouse of the defendant or ex-spouse, even though she doesn't want him killed, we're going to let the jury decide.
Okay, so let's now also listen to what happened yesterday when Tim Jones' dad, who testified in the guilt phase of the trial, now in the penalty phase, is pleading to save his life. And let's listen to a very unique specimen of what he showed the jury on his back.
Thanks a little while. Yes, sir.
You know, after you see that, you do take a breath. Now, Gene, that was the father defendant, Tim Jones. I don't know about you, but I didn't like the taking of the shirt off in court. I could have think they could have been as effective by using photographs, which are eventually entered into evidence. What's your thoughts about that?
That came very close to offending me. And I don't know what the defense attorney was thinking. If the father wanted to do that, then all bets are off. Even if the father wanted to do that, Linda, I would have said, no, we're going to take a photo. We'll even take a video. But that was degrading to me. And I don't know
degrading for him, I felt, right? Right.
For him. You're humiliating the father of those grandchildren.
Yeah, when you're trying to save who's trying to save his son's life, Gene, right?
What was the end goal of doing that?
Well, you know, Gene, we're going to have to see, because the jury is going to render their decision pretty soon, I assume this week. And, you know, if they get one and it's all over. But, you know, next, Gene, thank you. I'll see you tomorrow. Aaron Keller is up next, the Daily Debrief. I'll be staying on as his guest here only at the Law&Crime Network. Do we do all these cases?